to resist arrest by a peace officer unless they're using unnecessary physical force to do it. Second, when the defendant provokes the use of physical force by such other person. So if you were what we call the initial aggressor or the provocateur, here it's provocateur, and you did it with the intention of causing death or serious physical injury by your response. Right? So you provoke another person. You start talking about, what have we seen when we talked about EED? Right? Somebody sees their spouse or partner in the act of committing adultery. You start telling somebody in order to provoke them, I saw your husband having sex with another woman. And you try to get them really riled up. And your intention in doing so is to get them so riled up that they'll do something and you'll be able to now use physical force against them. Of course, that's kind of weird. But and then you try to use the self-defense. Say, oh, they were all upset. Well, you caused that, so you don't get to claim self-defense in the use of force. And finally, related to that, where the defendant was the initial aggressor, right? Not just provoking, but actually initiating violence. So if you're the initial aggressor, you lose your right of self-defense, with two exceptions, right? So that first we're saying you can't use self-defense, you can't use physical force if you were the initial aggressor, but two things. If your initial force by which you were the aggressor was non-deadly, and the force returned in coming back your way is such that it gave you reason to believe you were in danger of death or serious physical injury. Okay, that's escalation. So if you started out with this unlawful physical force, and the person you use force against comes back with deadly physical force, putting you in fear of death or serious bodily injury, you regain your right by the virtue of the fact that they escalated. Okay? And last, another exception, if you withdraw. You were the initial aggressor, but now you've seen the light, you realize that was not a good idea, so you withdraw from the encounter and communicate to the other person that you want out. And they keep going. Now you regain your right of self-defense. Okay? Questions about this sort of basic landscape framework? And again, we will see how duty to retreat / stand your ground fits in with that.
What is lawful physical force?
Is that a question of fact?
Let's say it's definitely going to be a question of fact. I mean, there can be a legal element to it, but it's ultimately a factual conclusion. What if, one of them is embedded in the statute. Let's say I see that Ms. Fields is being attacked by which professor is most likely to attack you?
Hall might go off though.
You have no idea how much that hurts me. We're going to go with Hall. His office is right next door to mine. I've seen the dark side. If I see Ms. Fields being assaulted by Professor Hall, what did we just decide, or what did we just say is part of my, what are the times when I can use physical force?
Isn't it to help someone else?
In defense of another, exactly. In defense of another. So if I then tackled Professor Hall in defense of Ms. Fields, I would be using physical force, but it would be lawful, right? Let's say then, who else do you guys have?
Abrams and Rothstein.
Let's say Professor Rothstein's on the same hall as the two of us. So Professor Rothstein sees this, and she decides to come to Professor Hall's aid, right? What? She could not use physical force against me because my use of force was lawful. So there are some times when the use of force is lawful, like in self-defense itself or in defense of another. So you can't use physical force. Self-defense melts away if your use of force is if the force you're responding to is lawful. Okay? And a lot of times in these initial aggressor situations, right? Your use of force was lawful because you were responding to the initial aggressor. Right? The initial aggressor came at you, you responded with defense and self-defense, and they can't say, aha, now I have carte blanche to come back at you because my use of force was lawful. Okay? Speaking of all of this, let's talk about a strong candidate for the most bizarre facts of the semester, Gleghorn, Miss Cull. Tell me about Melody Downs. Melody Downs, just that name alone is a perfect name for a criminal law case. And we begin with her.
So she rented out her house to a number of people, including Michael Farrell. She rented her garage to him for $150 a month.
But it's not the $150 a month that causes the trouble, is it?
No. She believes that she's getting a radio as a part of the rent, and he believes that he's just allowing her to borrow it. But she sells it, so he gets upset.
So he asked for it back.
Right.
And she says, it was mine. It was part of the rent agreement, and I sold it. And on a scale of 1 to 10, 1 being he took it well, just shrugged his shoulders and said, them's the breaks. 10 being nuclear meltdown. How does Farrell respond to this?
Nuclear meltdown.
Nuclear meltdown. What did he do?
He smashed all the windows of her car, slashed her tires, dented the
Did he
car.
smash all 4 tires?
It doesn't say. It just says slash the tires.
Did he cut anything into the leather seats?
Maybe hit me.
Maybe he left a snake in there. I don't know.
He left a snake. So he slashed tires. He kicked in her door, scattered her belongings, and what happened to the aquarium?
He busted it bringing her pet snake.
Her pet snake.
Yeah.
And of course, Melody Downs has a pet snake. This case would not be complete without a pet snake. So then what happened?
Melody goes to the defendant and she tells him what happened.
And who is the defendant?
Gleghorn. He's another co-tenant in the house.
He also lives in the house.
Yeah.
And what happens with Farrell?
So he tries to get into the garage, and while Farrell's sleeping, and he said that.
Well, Farrell's sleeping.
Yeah.
And where is he sleeping?
In the rafters.
Right. He's got a mattress in the rafters, just laid out there, no actual bed, because he's in the garage after all. And so he's just passed out asleep because he had a lot to drink. And Gleghorn,
Right.
what does he do?
He he opens the garage door, he has a stick in his hand, and he begins beating the rafters and telling Farrell to come down.
Why? Why does he want Farrell to come down?
It's, I guess, to avenge.
No, he says pretty clearly what he wants.
Wants to kill him.
Wants to kill him.
Yeah.
Now, Ms. Call, let's imagine you're sleeping in the rafters of a garage. Now, hopefully this does not happen ever, but let's say you are. And somebody pounds on the door, comes in, and says, come down so I can kill you. Well, how are you, a sensible, rational human being, going to respond to that gracious invitation?
Probably not going to grab my bow and arrow, but I might call the police.
Well, that's in the day and age of cell phones, you might call the police. I don't think that was really an option available to Farrell.
Right.
But are you going to come down and say, sure, why not?
No.
No, that's probably not something that you're going to be all keen on doing, right? So, so Gleghorn, not getting satisfaction because Farrell won't join him on the ground floor, what does Gleghorn say?
He says that he would burn him out, and then proceeded to set some of Farrell's clothes on fire.
So he's saying, I will burn you out, and by the way, I have the means to do it, your clothes being part of the means, right? So lots now has been sacrificed in this story. A snake, an aquarium, car tires, and now Farrell's clothes. So what happens next?
Farrell grabs a bow and arrow.
Because of course, in the perch, a bow and arrow is going to be ready at the waist, right? This is like an episode of The Walking Dead now, because we have a bow and arrow being shot. And so, what then happens?
It's kind of ambiguous as to what happened, but he said that he loses an arrow and he doesn't see where it landed, but it hit right.
What does he do once he realizes, what's his next step?
He comes down.
He comes down to see, what did I hit? Was I a marksman, whatever? And what happens when he comes down?
As soon as he's down, he gets hit from behind.
And he yells for someone to bring a hose. Please save my clothes, or something to that effect, because put out the fire. Gleghorn had been wounded in the back by the arrow, but he continues to beat Farrell, breaking his jaw, knocking out several teeth, and more. So this is quite the story. Okay? What is defendant charged with and convicted of?
The jury returns a verdict for simple assault as a lesser included offense of assault by means of force likely to incur great bodily injury on count 1, and battery with infliction of serious bodily injury on count 2.
So simple assault, and what was the battery charge?
Battery with the infliction of serious bodily injury.
Okay?
There was originally the charge was aggravated assault, right? That is assault likely to incur great bodily injury. And the court says, no, you didn't do that. The jury says, no, only assault. And he argues, what does he argue? He has a very clever little argument here.
So he argues that because the jury found that prior to being shot with the arrow, it was only simple assault.
So because the jury found only simple assault, which means that he did not act towards Farrell
With the intent to cause great bodily injury, or that his conduct was not likely to incur great bodily injury on Farrell. What does he then say about Farrell?
Since the victim responded with deadly force, he was entitled to defend himself with deadly force.
because Farrell was not justified in using deadly physical force. And what deadly physical force was that? The bow and arrow. And defendant was thus allowed to respond to the deadly physical force. And that affects this count, right? This becomes justified self-defense if Farrell was not justified in using deadly physical force. Okay? If, on the other hand, Farrell had been justified in using deadly physical force because of responding to Gleghorn, then this would be lawful. Right? If Farrell was justified, then it would be lawful deadly physical force, and defendant would not be allowed to respond for the reasons we just talked about. See, everyone see this? Everyone with me? So that sounds like a really neat argument, right? The jury found I committed only simple assault. That means Farrell was escalating. And if he was escalating, A, I regain my right of self-defense, and B, that escalation was not itself lawful. And if it was not lawful, then I'm allowed to now respond to it. And this count is the one that's at issue. This count has to be vacated on appeal.
But wouldn't Gleghorn's original threat kind of cancel that out?
Well, not if he escalated. Remember, escalation restores the right. If Farrell escalated, if we say Gleghorn's the initial aggressor, as we just said about Kentucky law, the initial aggressor, yes, loses his or her right of self-defense unless they unless they retreat and say, I'm out, or if the other person escalates. Gleghorn's argument is, yes, I may have started this, but this was an escalation, and escalation restores my right of self-defense. It's like it was gone, and the other person's actions, by escalating it, give me it back. That's the argument. Right? Because Farrell was not justified, defendant was then justified or allowed to respond. Because the threat of force, the use of force by Farrell was unlawful, and because it represented an escalation. What's wrong with that argument, Ms. Call? Sounds really cool. Sounds like it's all neatly wrapped up with a bow. Very good defense lawyer, clearly. Why does the court say not so fast?
Even though it wasn't the case in his life, but if Farrell's life was in danger, he reasonably believed that because of the appearances, and that made his use of force justified.
Right, or certainly lawful.
Right.
Right? The Farrell may not have been justified because he didn't actually face a threat of deadly physical force, but he believed he did, and the jury could have found that. The jury could have found, yeah, the simple assault charge means, from Gleghorn's perspective, he was not likely to inflict death or serious bodily injury, so he's only simple assault. But now we turn over and we look at it from Farrell's perspective, and he could have reasonably believed that. I mean, look, all he saw was a fire, and a fire, turns out it was just some clothes on fire, no accelerant, no backup to it. It was just an empty threat. But he didn't know that from his perch in the rafters. He thinks, oh my God, I'm going to be burned out here. Right? So, yes, Gleghorn might not have been guilty of the more serious assault charge, but Farrell might have thought he faced a more serious threat. And that means he was lawfully using deadly physical force, and that means this charge can stand. So you got to work through these steps. What was the actual use of force? What did the defendant believe was the use of force? Was escalation involved? All of those steps to make a decision about what's the right outcome.
I have a quick question. So I thought also in the court's holding, didn't they say that his Gleghorn's attack on Farrell was once Farrell had been hit from behind, he was pretty incapacitated, so his beating Farrell was just he said he didn't pose a threat anymore anyway, so this was just
Yeah, I mean, that's also in there, but I don't think that's important for us to understand the law, so I sort of want to put that to one side. These are the steps about escalation, reasonable belief, initial aggressor. Those are the things I want you to take out of the case.
So, Farrell, does he have to infer that imminent peril from someone physically doing something, or can he do that from the threat of them saying that?
I think all of the above, all the circumstances. If, let's say, Farrell had been charged for the bow and arrow, for that use of force, the question would be, from what would you as his defense lawyer say gave him a belief, hopefully reasonable, but even if it's not reasonable, at least enough to mitigate it down to reckless or wanton behavior, right? But hopefully reasonable. You're going to try to convince the jury he had a reasonable belief from all the circumstances. The threats, the banging, the fire, all the circumstances that gone on earlier in the day. Maybe there was a relationship between Gleghorn and, what was her name again? Melody Downs, right? And he would be very protective of her. All of that. You're going to want to say he had every reason to believe the threat was real and the threat was serious. And hopefully you convince the fact finder of that. Okay? Anything else about Gleghorn? All right, that takes us to Lydholm. Janice Lydholm was charged with murdering her husband Chester on August 7th, 1981. This followed years of alcohol abuse, then moments of kindness, and moments of violence. On the night of August 6th, that is the night, because this happens after midnight, the killing, they had attended a gun club party in Washburn, and they had both had a lot to drink. On the way back to their farm, an argument ensued, continued right up until they got home, and inside the house, Chester was shouting, and Janice, the defendant, Janice Lydholm, was crying. She tried to call a sheriff's deputy, but he physically stopped her by shoving her away from the phone and pushing her down, and repeatedly shoved her thereafter. After they went to bed, Chester falls asleep. Janice gets out of bed, gets a butcher knife from the kitchen, and stabs Chester. He dies minutes later. What happens at trial? What's the outcome at trial? Ms. Richter.
She was found guilty of manslaughter and sentenced to 5 years in prison.
And more? What else about the 5 years in prison?
3 years was suspended.
3 years was suspended. Now, if I'm her lawyer, I look at that outcome. She gets essentially 2 years in jail, because of the 3 years suspended, for stabbing a man who was asleep and killing him. And I'm thinking, that sounds like a pretty successful outcome, all things considered. I mean, we're going to consider a lot more, so maybe I shouldn't say all things considered, but from what we know so far, wow, that could have been potentially a lot more serious ramifications for Ms. Lydholm. But they are not satisfied. They do not think this is a successful outcome, and they appeal. So what does she challenge on this appeal? What does she challenge? Ms. Ramaswamy.
She said that the jury should have been given a different instruction based on the fact that she had battered women syndrome.
What had the trial judge told the jury?
They said it was they did not need to consider that in North Dakota law.
More specifically, what did the trial judge actually tell the jury was called?
To use an objective standard, so whatever reason.
I would like the actual instruction,
Oh.
if you can.
The circumstances under which she acted must have been such as to produce in the mind of reasonably prudent persons.
Okay, stop there for just a moment. Notice our invocation of reasonableness. Must have been such as to produce in the mind of reasonably prudent persons. Okay, go ahead.
Regardless of their sex, similarly situated, the reasonable belief that the other person was then about to kill her or do serious bodily harm to her.
So, regardless of their sex, if you're the jury, you're being sort of guided in a very clear and direct way that you are not to consider the defendant's sex or gender. You are to consider whether a person similarly situated, whether that person would have had, in the mind of a reasonably prudent person, the reasonably, so reasonableness comes in twice here. The reasonable belief, what, again, Mr. Bonnke?
That the other person was then about to kill her or do serious bodily harm to her.
And what does that, what concept is suggested there?
Imminence?
Imminence was then about to kill or do serious bodily harm to her. And so we've got our reasonableness, we've got our imminence, we've got reasonableness twice, and we've got regardless of sex in the definition. Okay? Well, what does North Dakota law say about this? Because the trial judge's instructions to the jury are supposed to reflect the law. Right? They're supposed to reflect the law. So we need to know what North Dakota law says on this. Ms. Ramaswamy, what does the statute say?
It says that they just have to have the reasonable belief that that the danger was imminent, and that it doesn't matter, I guess, what sex you are.
What does the statute say, Mr. Cannon?
Is it a subjective standard for what that person, that individual?
Now you're getting to the court's ruling.
Oh,
You're getting to the court's ruling. What does the statute say, Mr. Webb?
It says a person is not justified in using more force than is necessary and appropriate under circumstances, but deadly force is justified when it is used in lawful anyone else against death, serious bodily injury, or the commission of a felony involving violence.
And force of any kind, that's exactly right, force of any kind can only be used to defend against danger of imminent, unlawful bodily injury, and in the case of deadly force, when it's necessary to protect against death, serious bodily injury, or the commission of a felony involving violence. Okay? So that's what the law says. Seems to have imminence in it, seems to have a pretty high standard for the kind of threat you face. If you can use deadly force, and I think we can all agree that stabbing somebody, especially when they in fact die, is deadly force. Okay? Now, the court gets into this discussion, which I don't want to spend too much time on, but gets into the discussion about the difference between justification and excuse. What is that difference?
Excuse applies to the individual person in that moment, and justification is more like if you're talking about just in general, you have.
No.
Justification is like a perfect defense for the self-defense where you believe reasonably.
Nope. You were on the right track, Mr. Wiseman.
So if a person's conduct is excused when they believe the facts are such that his conduct is necessary. and
But?
necessary. So it's like whenever they believe, but their beliefs are mistaken, but they still reasonably believe that they're like in danger to their self.
And what's justification?
Justification.
When their belief was correct.
Exactly. Justification, if you're on 567, is when there is the actual existence of circumstances to make proper and legal what would otherwise be criminal conduct. That is you're justified. You are justified when you actually face a threat of death to kill somebody in self-defense. Excuse is, well, you believe they existed even when they did not. And we excuse your conduct. We don't say it was justified, because it's not justified to mistakenly, wrongfully kill somebody in the belief. But we excuse it in the face of your belief. Okay? And if that belief was reasonable, then there is no practical difference between whether the belief is justified, i.e. you were right, or you were excused because your belief was wrong. The end result is that the person avoids punishment for his or her conduct. Okay? But you want to think in those terms that justification is about being right, excused, fully excused, is about having a reasonable belief even though you were wrong. That leads us to, what if you have a genuine belief, an honest belief? Obviously, if you can't convince the fact finder that you had even an honest belief, that you didn't have the belief, then you lose, period. But if you had an unreasonable belief, but you really had it, then we get imperfect self-defense. And that is mitigation. We talked about that under Kentucky law. The statute says you get it mitigated down to a crime that would be recklessness or wanton. Okay, and the court says we do that exact same thing here in North Dakota. Okay, so since reasonableness is such a critical issue, right? It's not such a critical issue about whether Lydholm was right or wrong, because as long as she was reasonable, even though wrong, she still gets the same result. She's not convicted of anything. But the difference between reasonableness and unreasonableness is huge. So how do we judge the reasonableness of the belief? This is the crux of the matter. This is what the court really talks about judging reasonableness. What does the court say, Mr. Reeser?
Well, they say it has to be a subjective or objective standard, and in North Dakota they use the subjective standard.
Traditionally, that's what they use? What's the traditional approach?
To use objective?
To use objective, right? The court talks about, and the statute seems to suggest by using the word reasonable twice, that the tradition has been we ask of an objectively reasonable person. And what do we do? What happens in this case that suggests a change in that traditional approach? What does the court say was wrong with the instruction, in other words?
It didn't take into account her physical and psychological characteristics.
And the court says on 569, it acknowledges that some courts have begun a move, and this is part of a general nationwide trend that was taking shape at this time. This case arises in 83, to take account of the circumstance, to ask instead whether the circumstances are sufficient to induce in the accused, from her point of view, an honest and reasonable belief. Okay? And so the court says that the finder of fact must view the circumstances attending an accused's use of force from the standpoint of the accused to determine if they are sufficient to create in the accused's mind an honest and reasonable belief that the use of force is necessary. So we have to guide the jury. Why? Because jurors aren't in that person's position. They haven't experienced what that person has experienced, and thus may not be able to sort of apprehend or comprehend what is reasonable to them. And so we begin to add more subjectivity, ask juries to do that, a difficult task to be sure, but perhaps the only one that can accomplish any sort of a just outcome, to decide if I were in that person's shoes, based on various characteristics and the circumstances they have experienced. If I were in that person's shoes, what would have been reasonable to me? Rather than just applying some universal objective standard from outside the viewpoint of the defendant. Okay? And so the trial judge's instruction cannot stand. The issue shouldn't be framed in terms of a reasonably prudent person, especially not regardless of their sex, but instead, if you look on 570, in terms of whether, the court uses the male gender, interestingly enough, he himself, that is the defendant, him or herself, in good faith, honestly believed and had reasonable grounds to believe was necessary for him to protect himself from apprehended death or great bodily harm. Okay? And so we begin to consider more than just what the jury might have assumed from its point of view. Okay? And I want to stop there. We'll talk a little bit more about Lydholm and the development of the battered women syndrome defense over time and the arguments about it on Wednesday.